Department desk symbol that's been used.
Thank you. I'd like to take you to paragraph 26 of your statement. Now, you'll see, you say there that if congregation elders become aware of a child abuse allegation, they are instructed to contact the legal department in relation to reporting requirements, and then the call is transferred to the service department. So, just to understand that, does that mean that if the authorities are to be informed, in other words, I withdraw that. If the authorities are to be informed, that is a matter for the legal department to advise on, and not the service department. Is that right?
That's correct.
So the service department does not involve itself in giving advice with regard to informing authorities?
Correct.
So would there be any circumstances in your experience in which the service desk would be involved in advising elders in a congregation to report an allegation to the authorities?
The legal department advises in relation to mandatory reporting because they will be fully aware of which states and what the requirements are. It wouldn't be correct to say that the service department doesn't advise elders on that at a spiritual level, because invariably the opening discussion with elders once they come through to the service department is if we're dealing with a current allegation or abuse that is alleged to be currently taking place, the first part of the conversation is in relation to where is the victim, what's been done to protect the victim. So certainly at a theocratic level and out of concern for the family, that's certainly part of our discussion, but not the mandatory reporting requirements.
Right, well, I just want to understand that then. You say the first issue to be addressed is where is the victim in relation to a current allegation. How does that then relate or transform itself into a reporting issue? How do you deal with that with regard to reporting to authorities?
Right. It relates simply to what needs to be done to ensure that a child, a minor, is not left in a position where they could be exposed to further abuse, not from a legal perspective or requirement, but from the fact that the guardian parent, the elders and each of us are primarily concerned about what's being done to protect the child. This abuse that's been reported, is the child currently in a situation where that could continue?
And advice that's given by the service desk to the elders when they make a call on this first call basis, is that advice then put in writing to them or confirmed in writing?
I'd say no, because we go through the same process each time, simply referring the elders to the printed advice that's been given in that regard, and so we just simply go through that same process. Generally, correspondence starts when we give that generic advice to the elders, remembering that often when the elders call in, they have very little, if any, information. They may be passing on a second or third hand or some rumour, some allegation. So in that first instance, we don't always even have names or details. So we provide the same advice each time from the published material, then ask the elders to provide us with, in writing, the details that we can assist them with.
Let me just understand that this generic advice you supply on each occasion? What is it? What's the substance of that advice?
If I can, I'd read from the Elders' Handbook, the bit that by rote I read each time.
By all means, please refer us to it. So that would be tab 120, I take it. That's Shepherd the Flock of God you're referring to?
Yes. Because I've been permitted to use the hard copy.
Yes, of course.
Excuse me on the ringtail reference, but it's page 131.
Yes.
So we refer the elders, they've already obviously called in, and then obviously the sentence at the end of paragraph 18 says the branch office will then give direction based on the circumstances involved in each situation. So we ask the elders at that point just to give us what basic information or detailed information that they have. Then reading the following portion, have the elders have their handbook and follow along, where it says child abuse is a crime. Never suggest to anyone that they should not report an allegation of child abuse to the police or other authorities. And myself and the other service desk elders, we always go and get a second elder so that we can both assist. So these calls are taken with 2 elders from the congregation, 2 elders in the service department. We then say, I think as I've mentioned in my statement, and I say with absolute conviction that I'm a father, I'm the grandfather of 2 little children, and you brothers, if there's any concern that a child, a minor, remains in a situation where they're in threat of harm, to go back to the guardian parent and assist them to do all they can, including going to the authorities, if that's what the guardian parent is willing to do, including going to the authorities, and remind them that the individual, that they will have the full support of the elders in doing that. Then we read on, if you're asked, make it clear that whether to report the matter to the authorities or not is a personal decision for each individual to make. There are no congregation sanctions for either decision. Elders will not criticise anyone who reports such an allegation to the authorities. If the victim wishes to make a report, it is his or her absolute right to do so. So, in reality, in the vast majority of phone calls that we get, they would relate to historical events or events where the guardian parent has already extracted the child from the situation. But we repeat the advice in every case. Do whatever it takes to make sure that the child is not in a situation where they can come to harm. And I quite passionately express that to the elders, because I know what I would do if that was my grandchild, and I know from the elders that we've heard from over the last few days that's what they would do.
So, Mr. Spinks, that's the generic advice you give, and then it's over to the elders as to what they do. Is that how we to understand it?
That's correct, although they would ring us back if they needed further discussion.
So you don't give specific advice in the particular situation and say you should do this or that. You put it at the level of generic advice as you explained to us.
I think we've consistently said, and we appreciate that that's a matter under discussion, but we're not claiming to have said that we have instructed elders to go to the authorities, and I'm certainly not stating that that's the case now.
The material we have, as you know, indicates more than 1,000 allegations, not one of which has been reported to the authorities. And I assume you know that in different states there'll be varying responsibilities to report under the civil law when you know or believe that someone has committed a serious offence. Can you help us to understand why it should be that none have ever been reported to the authorities?
Again, Your Honour, we're not going to at any point suggest that we have telephoned the authorities or have instructed elders to do that. But as the Commission would be aware, almost 400 of those 1,000 cases over 65 years have had the intervention of the authorities. And we're not taking the high ground there and saying that we've telephoned the authorities, but realistically, almost 400 of those have been dealt with by the authorities, of which less than half have resulted in convictions. And if I can, with respect, I don't want to in any way diminish the number, because I hate it as much as you do in saying it. Those 1,000 cases over 65 years, and I took great respect at your observation the other day that this is not a competition, so I'm loath to say anything that none of us want to go there. This is about making sure that organisations, Jehovah's Witnesses especially, do all we can and more than we've done to make sure that we're addressing this, and we welcome the opportunity. Those 1,000 cases, as the Commission is aware, 199 of those relate to individuals, and I don't want to diminish the number, I'm just presenting the facts. 199 of those relate to individuals that were either not Jehovah's Witnesses or likely may not have been Jehovah's Witnesses at the time. More than half of the allegations, well over half of the allegations are familial, and in the context, with no comparison, where we're looking at ministers, clergy, those allegations include everyone who's ever walked into a Kingdom Hall of Jehovah's Witnesses, every individual who's ever studied the Bible with us in prison, every person out of the community that associates with us where we've become aware that there's a child abuse allegation. We have followed it up, recorded it, and that's the reason there are those numbers. In the last, and I take no pride in this number, it disappoints me, and it's why we want to cooperate fully. In the last 10 years, according to the statistics, that we've not done with the accuracy that the Commission has done, and so that's a lesson for us too. But in the figures that the Commission has provided, in the last 10 years, 2 elders have committed child abuse offences. In 10 years, 2 elders, and both were dealt with by the police. In the last 10 years, 4 ministerial servants have been involved in child abuse offences, and 3 of them have been dealt with by the police. And that includes child pornography, that not just sexual assault, but child pornography. Now, I only say those to put some context to it. We agree totally. We're not trying to disguise the figure. We have willingly handed over, perhaps one of the only organisations that's kept extensive records on visitors and parishioners, and we just look at it in that context, Your Honour.
Well, I don't want to get into a complex discussion with you about this, but you do understand that the way your church is structured means that you have an internal process which looks at allegations of abuse, and for that reason the collection of your files will capture abusers, whoever they might be. You understand that?
Yes, I do.
And the fact that you have an internal process of adjudication means that within your church you are establishing a true belief in the guilt of someone of a criminal offence. Do you understand that?
Yes, I do.
And you understand that carries with it obligations, irrespective of whether a matter otherwise goes to the police or other authorities, carries with it an obligations upon those who make the decision that an offence has been committed to tell the authorities that they have come to that belief. Do you understand that?
I've been made aware of that since the Commission started, Your Honour.
Yes, because at the end of the day, whatever might be the church processes and consequences, the state has an interest in ensuring that the criminal law is enforced.
Absolutely.
And that hasn't been the case in the past, I assume. I
think we've acknowledged the fact that as an organisation, while we've cooperated with the authorities and certainly in mandatory reporting, but I think we've acknowledged the fact that we have not had a practice against the wishes of the victim or otherwise to directly report to the police. I acknowledge that.
Even when you know that an offence has been committed?
We've acknowledged the fact that we've not taken away from the family, and while we're happy to accept whatever recommendations come, and I think Your Honour would be aware that we have no issue with mandatory reporting. That doesn't excuse anything. It's not suggesting that we're transferring the responsibility, but our challenge, as it has been for religious organisations, and I read it as I've waited over the last number of days, I read it in the publication that's given to victims here at the Commission from New South Wales Health, that says the victim should be given the right to determine whether it's to go to the authorities or not, and that booklet that's handed to the victim says, and their wish in that matter should be respected. Now, that's religiously the approach that we have taken for the reasons that have only been sort of briefly described, but what we recognise is once there is mandatory reporting, if regardless of our strongly held religious belief that individuals should have the right to determine what's done with that information, that's how we feel. It's based on scripture, but we accept when the state says that you are required to mandatorily report that offence, that Jehovah's Witnesses will do it, and if and when there are mandatory reporting requirements with some sort of uniformity across this country, we will willingly and happily comply. In the meantime, we've got that ethical challenge of respecting the individual's right, as the New South Wales brochure says, and as the scriptures say.
There's a subtlety in the proposition I put to you that may have escaped you. You see, what's happening within your church is you are actually determining whether or not you believe an allegation to be true. Do you understand?
Yes.
So, and if you determine that it's true, the state of knowledge of your elder ceases to be knowledge of an allegation, but becomes knowledge or belief that something has actually happened by way of a criminal offence. Do you understand?
Yes, I do.
Now, I know that you may have some idea of mandatory reporting, but what I was seeking to direct your attention to was that in those circumstances there will be some state laws, they won't be uniform across the country, but they'll differ from state to state, which will impose a criminal sanction on a person who knows and doesn't report. Do you understand?
It's been very well explained to me in recent weeks, Your Honour, so yes, I do.
But you won't get, at the moment anyway, a national response to this. It'll vary from state to state. You understand?
Yes, I think I've come to that conclusion too.
And what that means is that people like you and others in the church need to have a very good look, maybe with the help of your lawyers, at what the law actually provides.
Yes.
And what you're doing is in many respects different to what other churches might be doing, because you're actually taking allegations and resolving, as you see it, the truth of the allegation by reason of your process.
Yes, I understand.
You understand?
Yes, I do.
Mr. Spinks, you'll understand that your service desk located in New South Wales, if it receives information from elders in a congregation also in New South Wales, then there may be, under compulsion of the criminal law, section 316, an obligation on the service desk to report to authorities, never mind the elders. Do you understand that?
That, as I mentioned to His Honour, that's been recently brought to my attention, yes.
So prior to that having been brought to your attention, I take it there may be cases where the elders have received, the elders at the service desk have received information from elders at a congregation which, under threat of criminal sanction, should have been reported but wasn't.
Well, I'm not qualified to answer, but if I understand your question, if you're suggesting that when a victim reports perhaps to a guardian or an associate, and that's reported to an elder who reports to another elder who contacts the legal department, is transferred through to the service department, and that at each step of the way there are legal sanctions that could result in criminal prosecution, if that's what you're saying. Yes, I do understand what you're saying.
Well, no, I'm
It
saying
doesn't quite work like that. You'll need to have, and everyone needs to have a good look at it. The section in New South Wales speaks in terms of knowledge or belief. Now, that's a state of mind, not created by hearing of an allegation. Do you understand? But I think maybe, Mr. Stewart, we need to put this into the ultimate report. I'm not sure we're going to get very far.
yes, Your Honour. I just have one further question in relation to this, to clarify what it is that I'm meaning, Mr. Spinks. A scenario, for example, of someone against whom allegations is made, then confesses to the elders in his congregation, who reports that confession to you or one of your colleagues at the service desk, and on the basis of that you would have the belief that the allegation was true, not so.
You have the knowledge.
You would have the knowledge that the man had confessed.
Can I ask you to repeat? I apologise. Could you just repeat that again?
What's been put to you is that there may be an allegation,
Yes.
but when the allegation is confirmed by the alleged abuser confessing,
Yes.
admitting that he did the act,
Yes.
then it ceases to be an allegation, but it becomes an offence of which the person receiving an understanding of the confession has knowledge,
I understand.
and the act will then operate.
Yes. And Your Honour, with respect, does that apply just to ministers, or would that apply to
Both,
every
to anyone.
every person in the
Yes.
state of New South Wales?
Well, who has the relevant knowledge.
Yes. Thank you.
Yeah.
Thank you.
So just getting back to the generic advice you offer. Now, you'll appreciate that, and particularly in relation to the right, as you put it, of the victim to report to the police, you'll appreciate that there may be a distinction on the one hand between a situation where a child has been a victim and is still a child, in other words, a recent allegation and is still a child, and on the other hand, an adult reporting with regard to some allegation some time back when he or she was a child. Do you see that distinction?
I do.
And dealing then with the first scenario, as I understand it, you would see that as being up to the parent of the child to exercise that right or not to report to the authorities. Would that be right?
Scripturally, that would be our position.
Yes. And in circumstances where, let's say, for example, the allegation of abuse is against the father and the mother doesn't want to report for whatever reasons, but one can imagine easily there may be reasons she doesn't want her husband to go to jail and so on. But the child remains vulnerable as a consequence. As I understand it, you at the service desk would not advise the elders to report to the authorities.
Again, we've been transparent in what we're saying. We have not instructed elders to say at arm's length in the office, you must go and tell the authorities. The language that we've used, as I've explained, and we ask them repeatedly to do it if that's the situation. Could you go back to the guardian parent and reinforce with them that if the child remains in a dangerous position, that we need to do all we can to make sure that the child is protected. Now, I could make a statement now to the effect that, well, you know, we know that that's always happened and then no child has been harmed further. I'd love to say that. But I can say that to my knowledge, and certainly in the time that I've been there, we have not allowed a situation to go unaddressed if the elders had that as a concern, and it has been my knowledge only, and again I'm not suggesting evidence to this effect or listing off names, I'm saying to my knowledge the care of the guardian parent would have already extricated the child from that situation, and repeatedly in situations over the years, that's with the assistance of the elders, the assistance with the congregation elders. But the short answer to your question, have we instructed elders to go to the authorities? We've transparently said we have not done that.
Yes, and Mr. Sphinx, have you followed the evidence of this case study over the last week and a bit?
I have.
And so you would have heard one elder after another, that's a congregational level elder, saying that they depend on advice and direction from the service desk.
Yes.
And you accept that's in reality what happens. They do depend on advice and direction from the service desk.
I do.
And is there not a gap then created between the generic advice you give and their expectation of being advised and directed, where it leaves, from your side, leaves them with discretion as to how to handle it, but from their side leaves them with an expectation of direction with regard to how to handle it?
If I understand the point there correctly, I do agree that we've said clearly that we haven't given that instruction to the elders. So for me to say that there's an expectation that the elders would have received that as an instruction and acted on it would be inconsistent. So the point you make is correct.
Right, just taking this point a little bit further, if we take a look at your paragraph 30, so you're dealing here, perhaps we're going to scroll down a bit so we can see the heading of this section, sorry, up. Branch Office Response, Victim Safety and Support. And you say there that you ask the current circumstances as you explained previously, that's in 28. And then we'll go down to 30, you say, I explain that as a father and a grandfather, if this was my child or grandchild, I would do everything necessary to ensure that the child is safe. And then you say, for the elders, that may involve supporting the parent or guardian in contacting the authorities or personally contacting the authorities. And then you cite an August 28, 2002 letter, and you extract a quote from that letter. Do you see that?
Yes.
That letter is at tab 105. If we could take a look at that. You see that's a letter from the branch to all congregations in Australia. Do we understand that to be to the elders of all congregations, or would it go to all the publishers?
When it's not addressed to the body of elders, when it's addressed to all congregations, it goes to all publishers as a letter read out of the congregation and posted on the notice board.
And on the second page, page 2, is the quote that you've extracted, which says, we have long instructed elders to report allegations of child abuse to the authorities where required by law to do so, even where it is only one witness. In any case, the elders know that if the victim wishes to make a report, it is his or her absolute right to do so. Now, of course, what that doesn't say is that the elders should themselves contact the authorities in any particular circumstances.
Correct.
And do you accept that indeed it implies the contrary? In other words, it implies that it's really up to the victim, or in certain circumstances the victim's parents, but really that it's not saying anything to the elders about the elders reporting.
Yes, you're right. I don't know that I'm saying that. I believe that the sentence in paragraph 30 is not a letter to the congregation, but me explaining to the Commission what I do. And as I've written there, I explain that as a father and grandfather, not the Watchtower Bible and Tract Society writing. As a father and grandfather, I know what I would do, and I'm explaining that for the elders, it may involve supporting the parent guardian or personally contacting the authorities, because in the same way that as an organisation, as a faith, we are respecting the rights of the individual, we also respect the individual consciences of the elders who, as we've seen, they're all family men, children, grandchildren, or whatever. We respect their conscience. We don't dictate in that sense what the elders can.
But if the elders are to have reference to the material as opposed to what you said to them on the phone, you would accept that certainly in relation to this letter, there's nothing that would encourage them under any particular circumstances to report themselves to the authorities.
I think we've said very clearly in several questions you've asked now, we've not claimed to have instructed the elders to go to the authorities, and we acknowledge that. It's somewhat different to, as we said, when the elders call in, encouraging them to do all that they can with the parent, guardian, their own conscience, etc., to do what needs to be done to protect the child. I can see the clear difference that you're making, and I accept it fully.
Now, just understanding where this letter fits in, is it current? It's a 2002 letter. I mean, to what significance are we to give it? And the reason why I ask that is it not the case that the current position is governed by Organised to Do Jehovah's Will in 2005? That's the baptismal handbook for all publishers, am I right?
Correct.
And then also Shepherd the Flock of God 2010, which is the handbook for elders, is that right?
Correct.
And then the letter of 1 October 2012. Do those documents not supplant this 2002 letter, or is there an expectation that this 2002 letter still has some currency?
It's pretty subjective to say. I mean, the letter wouldn't be on notice boards now, but I don't see anything in that sentence there that's any different to what we would do now, but I'm not sure of the point you're making.
Well, no, I'm just seeking to understand why you draw on a 2002 letter in support of the point or part of the point you're making in paragraph 30 when, as I would understand it, but I'm giving you the opportunity to show me where I've gone wrong, that letter is in the relatively distant past and has no currency.
I think that was an expectation on our part that you wanted us to establish that what we're now clearly saying in the publications is what we said in 2002, and we have long instructed elders. So elders have been contacting the legal department for beyond the last couple of decades. So I think we've simply tried to say, as we have with the other documents we've provided, that we've tried to establish a pattern of these principles over a period of time. But what you say is true. We could have easily put a more recent reference there.
And just if we can go back to your statement, this time at paragraph 32. You will see that you say their spiritual comfort provided by elders to a victim is not viewed as a substitute for professional therapy. You will have heard me ask some questions of Dr. Applewhite about this. It's still the case, though, that there are restrictions imposed by the Jehovah's Witness Church on its members with regard to the types of therapy that they can, at least with the blessing of the church, engage in.
I disagree with that completely. If I can show my reason for saying it, and that's in chapter 4 of the Elders' Handbook.
So that's tab 120.
Yes. page 55.
And that's at ringtail 56.
So when this point was previously brought up, with respect, I thought to myself when I read that paragraph, I'd like to write it for a publication that was to be presented for the general public. So I acknowledge the fact that this is written in the language of and written for elders, but it says there are times, paragraph 25, when an emotionally, the section is on helping child abuse victims, by the way. There are times when an emotionally distressed Christian may seek professional help, whether a Christian or his family pursues treatment from psychiatrists, psychologists or therapists is a personal decision. An elder should not assume the responsibility of recommending a specific practitioner or facility. He may draw attention to or discuss material in the publication that provides cautions regarding therapies that may conflict with Bible principles. So he draws attention to some references. It continues, while participating in group therapy by a professional therapist is a matter for personal decision. And then there's a caution again, there could be a revealing of confidential facts about other members of the Christian congregation during such sessions if a Christian does not exercise discretion. So there's some comments to the elders to say those are personal decisions. As you're probably aware, there are a good number of psychiatrists, psychologists, therapists, welfare workers that are Jehovah's Witnesses and have good knowledge. They're on occasion a professional that has no respect for an individual's faith in or belief in Bible principles, and we absolutely respect their right to make that decision. Whether that's, in that individual case, the best person to help a devout Christian who wants psychiatric help, wants therapy, but doesn't want their faith mocked or undermined, that's the balancing comment in there. But we have no objection to professional treatment, and I would say that a good number of those that have been affected by past child abuse have sought and received help, the ones that I'm aware of.
Well, let's just break this down a little bit. In the latter aspect, the bit about while participating in group therapy by a professional therapist, while participating in group therapy by a professional therapist is a matter for personal decision, there could be a revealing of confidential facts about other members of the Christian congregation during such sessions. Is this not to be understood as a caution to members that if they are to participate in group therapy, they must not reveal confidential facts?
I'm not sure where you're reading that. To me, the word discretion or a matter for personal decision, I see the point that you're trying to make and where you're trying to lead, but what I read is a matter for personal decision and a matter for discretion. It says there could be a revealing of confidential facts. I don't see the don't or can't or whatever. I see discretion and I see a matter for personal decision. But I agree the sentence could be better written to be read in this context.
Let's just look at it. Mm-hmm. The first half of the sentence says, in essence, whether or not to participate in group therapy by a professional therapist is a matter for personal decision by the publisher in question. That's what the first part says, not so. So that's what the personal decision is about. It's whether or not to participate. Do you agree?
Yes.
And then it says that the reference to discretion at the end of the sentence is not a discretion in the sense of it's a matter for their discretion as to what they reveal or not. It says that if they do not exercise discretion, they will reveal these things which they must not reveal. Discretion in the sense of caution, not authority.
I understand exactly the point you're making. I don't question it. I don't read it that way, but I'm happy for you to read it that way.
Is it not that the case that elders, the expectation is elders would read it in the way in which I've put it rather than in the way in which you've put it?
Well, that's not been my experience at all.
Okay, let's look at the other part of it. It says, he may draw, so this is the sentence just before all the references. He may draw attention to or discuss material in the publications that provides cautions regarding therapies that may conflict with Bible principles. So I take it there are therapies that conflict with Bible principles.
Yes.
And what are those?
I'd have to take the references out and again to be accurate, but there are certainly some therapies by their nature or religious practice that may involve what the Bible would refer to as like spiritistic type practices, mainstream therapy, normal psychiatric, psychological therapy. That's not what's being referred to. It's making a reference to publications that have highlighted perhaps some of the more extreme and radical therapies that have been done, and says he could draw their attention to it.
Would this be a convenient time?
We'll have the morning adjournment.